Thank you, everyone. Please be seated. Okay, good morning, everybody. My name is Commissioner Hughes. This is the 8 a.m. initial appearance calendar for Thursday, March 6th. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of March will apply to the hearings on this calendar. As we get started in here this morning, I will call each of you into the courtroom one at a time. I will ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next person or next two people that I intend to call to line up in the chairs right inside this door. I think there's one blue and one green chair right inside this door. So that's how we'll cycle through this calendar. The first person, when I call your name, I'll ask you to come all the way into the courtroom, and I'll ask the second and third person to have a seat in those chairs. And then as I continue to call names, you'll just sort of move from chair to chair into the courtroom. I know it seems a little bit silly to do it that way, but I assure you it will make this calendar move quicker. There are a lot of you in here, so if you will listen carefully for your name and follow those chairs, I promise you it will get all of us to where we need to get to after this a little bit quicker. Okay, once you are in the courtroom and you're behind the podium, the first thing I will do is ask you to state your full name and date of birth. I will then explain to you why you're here this morning. I will tell you whether you qualify for a court-appointed lawyer, sometimes called a public defender, to represent you. If you do not qualify for a public defender, you have the right to hire a lawyer to represent you. That's true even if you do qualify for a public defender. You always have the right to hire counsel of your choosing if you wish to. After we talk about whether you're entitled to a public defender, I will give you the next court hearing dates and times that you will be required to attend after this court hearing. And the last thing we'll do while you're in here is discuss whether you are legally eligible for release from custody. If you are, we will go over the terms and conditions of your release. In addition to that right to the assistance of counsel, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you do choose to say in the courtroom this morning can be used against you at any point down the line in these proceedings. Unless you have made arrangements with a private lawyer to appear at this hearing this morning, you will not have a lawyer present for purposes of your defense. Those of you that will not have a lawyer in, well, for all of you, but primarily those of you that won't have a lawyer in here, I strongly caution you against making any statements regarding the facts about your case. I encourage all of you to discuss any comments, questions that you have about the facts of your case with legal counsel before you make any statements on the record that you then can't take back. Last thing I will tell you all before we get started is that everything I tell you while you're in the courtroom will be contained in a written document called a release order. You will get a copy of that document when you're done in the courtroom. You step back into the room that you're in right now. So please don't feel like you need to memorize dates, times, information that we go over in the courtroom, but do please keep that paperwork with you wherever you go from here this morning, because in that paperwork will be all the information that we went over while you're in the courtroom. Okay, let's go ahead and get started. Can I please ask Juan Hernandez to come all the way into the courtroom behind the gray podium? Ruben Velas, if you would work your way to the first chair inside the door. Adam Ostrander, if I could ask you to work your way to that second chair, please. Okay, good morning to you both. Mr. Hernandez, can I ask you to please state your name and date of birth?
My name is Juan Gilbert Hernandez, 10/29/79.
Thank you very much. An appearance of counsel, please.
Cameron Morgan, appearing for Mr. Hernandez, Your Honor. I filed an NOA.
I have it. Yes, thank you. Good morning, Mr. Morgan. I just want to confirm one thing with you. I just want to make sure I'm entering the correct lawyer in this case. Is your bar number 006709?
Correct.
Okay, thank you, Mr. Morgan. Okay, Mr. Hernandez, you are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains several counts. 1, conspiracy, a class 2 felony. 2 counts of narcotic drug possession for transportation or sale. Those 2 are also class 2 felonies. 1 count of illegal control of an enterprise, which is a class 3 felony. 10 counts of misconduct involving weapons, all class 4 felonies. And last, 1 count of marijuana possession for sale. That's also a class 4 felony. I am not appointing a public defender to represent you. Mr. Morgan has filed a notice of appearance in this case. That notice of appearance is for all the proceedings, not just this hearing. So, Mr. Morgan, I do note you counsel of record. All communications moving forward will be sent to you. Okay, the next hearing in this matter will be an arraignment hearing, specifically a not guilty arraignment hearing, March 13th at 8:30 in the morning. It'll be in the Superior Court downtown. I am inclined to affirm the bond on the grand jury warrant. However, I am willing and interested in hearing any arguments or information that you'd like me to consider, Mr. Morgan.
Yes, thank you, Your Honor. What is the bond set by the grand jury?
It is an $80,000 cash bond.
I'd like to be heard then, Judge.
Please, proceed.
Judge, with respect to ties to the community, the defendant has lived here most of or all of his life. He has a home, family, job with Fox Electric. He's got significant ties to the community, and with respect to whether he is a threat to the community, it appears to me that he may have one prior marijuana conviction. He successfully completed probation. His rights were restored. I'm really kind of concerned about that. He's got 10 counts of misconduct with weapons for weapons that were seized in his house, but his rights were restored, so I think there may be a mistake as to the grand jury presentation. He has no prior FTAs that I'm aware of, and this is, I would assume, a non-dangerous offense, and he's not a danger to the community. I think $80,000 cash is a little bit too high. I would request an OR or a minimal bond considering his ties to the community and the lack of, and the fact that this appears to be a marijuana case, Judge. And I looked at the bond. It says it says issued 12/30/2024, and it says no bond. I'm not sure what the no bond meant on the Form 4, but it seems to me that anywhere from a $0 to $5,000 bond would be sufficient to guarantee that he would attend all his hearings and prosecute the case.
Okay, thank you, Mr. Morgan. I just want to double check. I do see that no bond on the Form 4. I'm with you. I don't know where that came from. The warrant does clearly indicate that it is imposing a cash bond of $80,000. So I'm with you on the confusion on that. I don't know how that happened. Okay. Mr. Hernandez, I hear and understand Mr. Morgan's argument that you have ties to Arizona. It sounds like you've lived here your whole life. I agree with him that your criminal history does not appear to indicate that you have failure to appear in court. It does indicate that you have one prior marijuana possession conviction. I don't know. I can neither confirm nor deny that your rights were restored. So it is possible, as Mr. Morgan indicated, that those misconduct involving weapons charges could be in error. It is also possible that they're not prohibited possessor charges, that there's something else that is the alleged misconduct in those allegations. I don't know. I am not the one that heard the presentation of facts. As we all know, it was the grand jury. So I say all that to say that I don't believe that you pose a risk of not appearing in court. I don't believe that a review of your criminal history suggests that you would be a danger to the community. My hesitation here in changing that grand jury amount is that I was not the one that heard the presentation of facts. So in balancing failure to appear's prior criminal history with whether the facts of this case suggest you would pose a danger to the community, I am not able to make that analysis. So I am going to defer to the grand jury warrant. I am going to affirm that $80,000 cash bond. However, Mr. Morgan, I'm going to do it without prejudice, understanding that I am making this ruling because I lack the facts of this case. So I affirm that warrant without prejudice, giving you free rein to file any motions to modify that you think are appropriate with the trial court if and when that judge is assigned. Okay, so you will have that $80,000 cash bond. If you post that and you're released from custody, you cannot have contact with any alleged co-defendants if there are any in this case. And while this case is pending, even if your rights are restored, you cannot possess any weapons or any drugs without a valid prescription. Anything else I need to address before I excuse your client, Mr. Morgan?
No, Your Honor.
Okay, thank you very much. I will say we have a long docket here, so if you'd like a word with your client, I think you're assuming they don't tell me no, it's okay. You're free to take this room with your client if you'd like. Okay. Ruben Velas to the podium in the courtroom, please. Emily Moreno, if you would work your way to that second chair. Good morning. Can I have your name and date of birth, please?
Good morning, Your Honor. Ruben Velos, 2/21/1980.
Thank you very much. I apologize for getting that wrong, Mr. Velos. You are here on a probation violation warrant. Sorry, my computer is moving very slow. Okay, a petition to revoke your probation was filed. It alleges that you have violated terms 1 and 12 of your probation. I have appointed a lawyer to represent you in the probation proceedings. Your next court hearing will be a revocation arraignment hearing. It will be March 13th at 8:30 in the Superior Court downtown. On this warrant, you are not eligible for release from release from custody. So what that means is you will be held in custody without bond, at least until you see the probation judge March 13th. What will happen after that hearing will be up to the probation judge on that day. Do you understand that information?
Yes, Your Honor.
Okay, thank you, Mr. Velosi. You can step back and get your paperwork. Adam Ostrander to the podium in the courtroom, please. Tony Soto, if I could ask you to work your way to the second chair. Good morning. May I please have your name and date of birth?
Adam Clark Ostrander, 11/29/1997.
Thank you very much, Mr. Ostrander. You are here on a probation violation warrant. A petition to revoke your probation alleges that you have violated term 1 of your probation. I have appointed a lawyer to represent you in those probation proceedings. Let me get through this. We'll get to you here at the end. Your next court hearing in the probation matter will be a revocation arraignment March 13th. It'll be at 8:30 in the probation court downtown. And on the probation violation warrant, you are not eligible for release on bond, so you will be held in custody without bail at least until you see the probation judge on the 13th. Go ahead.
So I just signed for a plea of 2.5 for a different situation.
Okay.
And my bond has not been exonerated yet. With this
from the underlying case?
Yeah, from the underlying case.
On that other matter.
Because I'm doing the 30 days of the signing because I was just on bond, and I have a paid lawyer.
Okay.
I'm represented by Colin Earl Sullivan. But my question is that will this plea that I've signed into now, and I'm just waiting to do the final sentencing, will it get revoked now, and will I be able to post a new bond because of this new matter?
So, two answers. Well, two different questions. One, in terms of whether the underlying agreement that you signed and are in the process on in a different case will be affected by this alleged term 1 violation, I don't know. Talk to your lawyer about that. The second part is whether you'll be able to post a bond on this case. The answer to that is potentially.
Okay.
It is possible that the probation judge on the 13th will reinstate your probation, give you a bond, and allow you to be released from custody.
So potentially, I may be looking at DOC time, but with this plea, potentially now.
Okay.
I just say potentially because of the new matter that just came forward with me.
Okay.
So my main question is that since the bond has not been exonerated yet, with the new bond being issued, if the plea gets revoked for whatever reason now because of the new matter, will I be able to get released and go back?
Well, I don't know. And I can't answer that question because I don't know what the case is that you just took a plea on. I don't know what the facts of the new allegation are. All I know is that there is some new allegation that is alleged to be a term 1 probation violation. Okay. I don't know what that alleged crime is, and I don't know how it would affect what the other things that you've taken a plea in is. So I don't know enough about all of your cases to be able to answer these questions, but your lawyer will.
Okay.
So talk to your lawyer about all of those concerns, and your lawyer can't, because right now you're going to be held in custody at least until the 13th.
Yeah.
So talk to your lawyer, ask your lawyer all of these questions, and then hopefully you get those questions answered and your lawyer will know what arguments to make to the probation judge on the 13th.
Could we handle this matter any sooner?
No.
Because of, Okay, so
No, I don't have authority over the court date.
So my next court date for that next matter is on April 1st. But if we get it figured out by March 13th, and we can get whatever.
Your lawyer will know how to tell the court what's going on. So just let your lawyer know that you were seen here on a Term 1 probation violation. Your lawyer will know how to tell the two different trial courts, if your cases are pending in two courts, that this is happening, and your lawyer can work with all of those judges.
It is globalized?
Already it is?
Yeah, it is.
Okay.
It is already globalized?
You won't get this one pulled in because probation works differently, but your lawyer will know exactly how to work with those.
Okay, understood.
Okay, thank you very much, Mr. Ostrander. There's your paperwork. You can head back to your left. Have a good day, Mr. Morgan.
Thank you.
Okay, Emily Moreno to the podium in the courtroom, please. My Kelty Bynum, if you'd work your way to the second chair. Can I have your name and date of birth, please?
July 29th, 1989.
And what's
Emily Moreno.
Thank you, Ms. Moreno. Okay, you are here on three different matters. The first matter you're here on is allegations of new charges. Those allegations are one count of narcotic drug possession, a Class 4 felony, and one count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those new allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $500 secured appearance bond. The other two matters you're here on are both probation violation allegations. In both of those cases, the allegation is that the new charges are a violation of Term 1. I have appointed a lawyer for you in both of those probation cases. Your next hearing in each of those two cases will be a revocation arraignment March 13th. It'll be at 8:30 in the Superior Court downtown. On one of the probation violations, you have a $5,000 secured appearance bond. On the second, you are not eligible for release on bond. So what that means is you will be held in custody without bail at least until you see the probation judge on March 13th. If on March 13th, the probation judge allows you to be released on bond, you could then look at posting that $5,500 bond on the other cases to be eligible for release on all three. Do you understand that information?
Yeah, I do.
Okay.
But Your Honor, I have to take care of my kids. I'm the only one that will take care of them. There's no way I can get like on an ankle bracelet or house arrest.
No, on that one probation violation warrant, you are not legally eligible for release. So you'll have to make some calls and get somebody else to take care of your children. If you genuinely have nobody, there is a hotline to the Department of Child Services that you can contact. If there is nobody else that can care for your children, it is their responsibility to care for the welfare of children. So reach out to the Department of Child Safety if you genuinely cannot find somebody else and you're worried about your children.
Okay, thank you.
Okay, thank you, Ms. Moreno. You can step back and get your paperwork. Tony Soto to the podium in the courtroom, please. David Jaramillo, if you would please work your way to that second chair. Good morning, sir. Can I please have your name and date of birth?
Tony Hernandez Soto, 4377.
Thank you very much, Mr. Soto. You are here on two different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. In that case, you already have a lawyer assigned to represent you. Your next court hearings in that case will be a new status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On the warrant in that existing case, you have a $250 secured appearance bond. The second matter that you're here on is an allegation of a new charge. That allegation is one count of drug paraphernalia possession. It is a Class 6 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you against that allegation. Your next court hearings in that new charge will be in part the same as your hearings on the existing case. So you'll have a status conference on March 12th and a preliminary hearing March 14th in both cases.
Today?
What?
Today they talking about the fact yesterday? What?
The alleged offense date is yesterday on the 5th.
Hey, get me on nothing. Just
Talk to your lawyer. Talk to your lawyer about the facts. Hold on, we're not done. Come back, we're not done. Okay, on the new allegations, because it is a felony offense alleged to have been committed while you were on pretrial release in that existing felony drug case, you are not bond eligible. So you will be held in custody without bail on the new allegation at least until March 13th at 1:30. Once you go to court on March 13th at 1:30, all right, thanks, sir. Mike Healthy Bynum to the podium in the courtroom, please. Jose Mendoza, if you would work your way to that second chair. Can I have your name and date of birth, please?
Oh, Mike Healthy Bynum, January 22nd, 2007.
Thank you very much, Mr. Bynum. You are here on allegations of new charges. The allegations against you are 1 count of armed robbery with a deadly weapon, that is a Class 2 felony, and 1 count of aggravated robbery, a Class 3 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing the 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $75,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that bond if you choose to. If you do post that bond and you are released from custody, you are prohibited from having contact with any alleged victims, witnesses, or co-defendants, and you cannot possess any weapons if you're released from custody. Do you understand those conditions?
Yeah. I just had a question.
Okay.
Since this is my first time getting in trouble, is there like any way I can get put like on ankle monitor or something?
No, I'm not willing to release you on an ankle monitor based on the underlying allegations and the nature of those charges. Based on the conduct alleged in this case, I have substantial concerns about the safety of the general public. So you will have to post that bond in order to be eligible for release. Any other questions?
So I gotta stay here.
If you don't post that bond, you'll stay in custody at least until your first hearing on the 12th. All right, go ahead and step back and get your paperwork. Thank you, Mr. Bynum.
Can I get my card out of my belongings? That's how I got my money.
That's a question for jail staff. I don't have control over that. Okay, David Jaramillo to the podium in the courtroom, please. Danita Hicks, if you would work your way to the second chair. Good morning, sir. Can I have your name and date of birth?
David Jaramillo, June 19, 2001.
Thank you very much, Mr. Jaramillo. You are here on an allegation of a new charge. That allegation is 1 count of aggravated assault with a deadly weapon. It is a Class 2 felony. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you.
Okay.
Your next court hearings will be a status conference March 12th and then a preliminary hearing the 14th. They will both be at 8:30 in the Superior Court downtown. On this allegation, I have imposed a $50,000 secured appearance bond. If you post that bond and you are released from custody, you cannot have contact with any alleged victims or witnesses.
Okay.
You are also prohibited from possessing any weapons if you're released from custody.
Gotcha. So quick question. So I have to post that bond tonight, right?
You can post that bond at any point. It doesn't have to happen today. It's just that you cannot be released from custody unless and until it's paid.
I need to get out like tonight, yeah.
I mean, you can use a bonding company. So when you get back into the jail facility, you can find a list of bonding companies and start calling them right away. As soon as that bond gets posted, you're eligible for release.
Can I call anyone? I also
you have access to all the phones in the jail.
Can I have my own phone by chance just for contact sake?
I have no control over what property you have access to and what you don't. So I'm not saying no, but you would want to ask jail staff that.
All right, cool.
Okay, thank you, sir. You can step back and get your paperwork. Jose Mendoza to the podium in the courtroom, please. Maximilian Rodriguez, if you would please work your way to the second chair. Good morning, sir. Can I have your name and date of birth, please?
Jose Mendoza, 1/17/1990.
Thank you, Mr. Mendoza. Did you say 90 or 80?
90.
90. Thank you, Mr. Mendoza. You are here on allegations of new charges. The first allegation against you is a new misdemeanor criminal trespassing charge. On that allegation, because it is a misdemeanor, you're not entitled to a court-appointed lawyer. So if you want a lawyer to represent you against that misdemeanor criminal trespassing allegation, you will have to hire one at your own expense. Your next court hearing on that misdemeanor allegation will be an arraignment hearing March 11th. It'll be at 8 o'clock in the morning in the El Mirage Municipal Court. And on that allegation, you have a $50 secured appearance bond. The second matter that you're here on is allegations of new felony offenses. Those allegations are 1 count of trafficking in stolen property, 1 count of burglary, 1 count of taking contraband into a correctional facility. Those are all Class 2 felonies. 1 count of burglary, 1 count of conspiracy, those are both class 3 felonies, 1 count of possession of a weapon by a prohibited person, 1 count of burglary as a class 4 felony, 1 count of dangerous drug possession, a class 4 felony, 1 count of possession of burglary tools, and 3 counts of criminal trespassing. I have found, it's 2 counts of criminal trespassing, 1 count of criminal damage. I have found probable cause to support those new offenses, and I've appointed a lawyer to defend you against those felony allegations. Your next court hearing in the felony case will be a status conference March 12th, and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On the new felony allegations, I have imposed a $50,000 secured appearance bond. So that means your total bond for both cases will be $50,050. If you post that and you are released from custody, you cannot return to the scene where the alleged burglary offense took place. You also cannot have contact with any alleged witnesses, victims, or co-defendants, and you cannot possess any weapons or drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Mendoza. You can step back and get your paperwork. Danita Hicks to the podium in the courtroom, please. Mariah Nicholas, if you would please work your way to the chair. Good morning. Can I have your name and date of birth, please?
Danita Hicks, 1581.
Thank you very much, Ms. Hicks. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains 1 count of narcotic drug possession for transportation or sale, a class 2 felony, alleged to have been committed July 1st of 2024. I have appointed a lawyer to defend you. Your next court hearing will be an arraignment hearing March 13th at 8:30 in the Superior Court downtown. On that grand jury warrant, you have a $25,000 cash-only bond. If you post that and you are released from custody, you cannot have contact with any co-defendants if there are any, and you cannot possess any weapons or drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am. Can I tell you something? I have a lawyer already.
Okay, is it a private lawyer or a...
It's for my other charge.
Is it a court-appointed lawyer or a private lawyer?
A pro bono lawyer.
That you arranged for or that was appointed by the court?
I don't know who did it.
Okay, so if that lawyer is...
She's doing my other 3 cases.
It is possible that she will take this case. It's also possible that she can't. I don't know. So here's what I will tell you. I have appointed a lawyer for you on this case. When you go to your court hearing on the 13th, if the lawyer that is there representing you is not the lawyer that you already have, but you want that lawyer to take you want the lawyer on your current cases to take this case,
yes, ma'am.
You can talk to the lawyers about that. They will know whether they can actually switch that or not.
Okay.
So just talk to either of the lawyers, either the one that's appointed on this case or the one you already have, and let them know that you have a lawyer, or, have them work that out.
So I could call her and ask if she could take the case, or just wait till the 13th?
If you have contact information for the lawyer that's working with you, yes, feel free to call her, give her the information off this release order, let her know you were seen on a new case. If she is willing and able to take it, then she can make arrangements to do that, and then she can be present to represent you on the 13th.
Okay, thank you.
Okay, you're welcome. Go ahead and sit back and get your paperwork. Maximilian Rodriguez to the podium in the courtroom, please. Tommy Duarte, if you would please work your way to the second chair. Good morning, sir. Can I have your name and date of birth, please?
Maximilian Rodriguez, May 6, 2000.
Thank you, Mr. Rodriguez. You are here on an arrest warrant that was issued after a direct complaint was filed alleging new allegations against you. The allegations in that direct complaint are 1 count of burglary, a class 4 felony, 1 count of attempted burglary, a class 5 felony, and 1 count of unlawful flight from a law enforcement vehicle, that's also a class 5 felony. I have appointed a lawyer to defend you against these allegations. Your next court hearings will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On that arrest warrant, you have a $25,000 secured appearance bond. If you post that and you are released, you cannot have contact with any alleged victims or witnesses of the underlying allegations, and you cannot possess any weapons or drugs without a valid prescription. Do you understand those conditions?
Yeah, I do. But I had a question. What is direct complaint? What is that?
It's a written document that alleges new allegations against you. So it is the county attorney's office filing a written document called a direct complaint, as opposed to law enforcement arresting you and booking you in.
Okay.
It's just a different procedural mechanism.
Yeah. There's no indictment though?
Not yet.
Okay, I was gonna ask, damn, I just had it in my head. You can keep going. If I remember, I'll ask you.
I have nothing else for you.
The date. What was the alleged date?
The date of the alleged offenses?
Yeah.
So the burglary allegation is alleged to have been committed April 24th of 2023, attempted burglary July 18th of 2023, and the unlawful flight September 1st of 2023. So it's like April, July, and September, all of 2023 for the alleged underlying conduct.
Okay.
All right. Thank you,
All
sir.
right.
Go ahead and sit back and get your paperwork. Mariah Nicholas to the podium in the courtroom, please. Juan Martinez, if you'd work your way to the second chair. Good morning. Can I have your name and date of birth, please?
Mariah Angel Nicholas, November 8, 2003.
Thank you very much, Ms. Nicholas. You are here on a bond surrender. The bonding company that allegedly posted your bond in the first place has surrendered, has called your bond and surrendered you. The underlying case that this is happening in is a case involving burglary allegations. You have a lawyer assigned to you in that case already, so that lawyer will continue to represent you. Your next hearing following this bond surrender will be a status conference March 17th. It'll be at 8:30 in the Superior Court downtown. And I am reimposing the original conditions in this case. It is a $25,000 secured appearance bond, and all of the other conditions are back in place. Those include that you not return to the scene of the alleged crime, that you not have contact with any alleged victims or witnesses, and that you not possess any weapons or drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay. Thank you, Ms. Nicholas. You can step back and get your paperwork. Tommy Duarte to the podium in the courtroom, please. Adrian Pineda, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Tommy Duarte, 12/23/1982.
Thank you, Mr. Duarte. You are here on allegations of new charges. The allegations against you are one count of conspiracy to commit possession of a weapon by a prohibited person, that is a Class 4 felony, one count of drug paraphernalia possession, a Class 6 felony, and one count of conspiracy to commit theft, that is also a Class 6 felony. I have appointed a lawyer to defend you against these allegations. Your next court hearing will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $25,000 secured appearance bond. If you post that bond and you are released from custody, you are ordered not to return to the scene of the alleged burglary allegation, the alleged theft allegation. You cannot have contact with any alleged witnesses or co-defendants, and you cannot possess any weapons or drugs without a valid prescription if you're released. Do you understand those conditions?
Yes, I do.
Okay, thank you, Mr. Duarte. You can step back and get your paperwork.
Thank you.
Juan Martinez to the podium in the courtroom, please. Cruz Trejo, if you would please work your way to the second chair. Good morning. Can I have your name and date of birth, please?
Juan Martinez, 07/08/1996.
Thank you, Mr. Martinez. You are here on an allegation of a new charge. That allegation is one count of aggravated assault by impeding breathing. It is a Class 4 felony. I have found probable cause to support that allegation, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing on the 14th. They will both be at 8:30 in the Superior Court downtown. On this allegation, I have imposed a $15,000 secured appearance bond. If you post that bond and you are released from custody, you may not return to the scene where the alleged underlying offense took place. You cannot have contact with the alleged victim for any reason. You also cannot possess any weapons. You cannot possess or consume any alcohol or drugs without a valid prescription if you are released. And whether or not you are released from custody, you are strictly ordered to comply with the terms of any orders of protection, if any have been or are later served upon you. Do you understand those conditions?
Yes, ma'am.
Thank you, Mr. Martinez. You can step back and get your paperwork. Adrian Pineda to the podium in the courtroom, please. Ramon Gomez, if you would please work your way to the chair, second chair. Good morning. Can I have your name and date of birth, please?
Adrian Pineda, October 9th, 1982.
Did you say 92 or 82?
82.
82. Thank you, Ms. Pineda. You are here on allegations of new charges. The allegations against you are one count of theft of a means of transportation. That is a Class 3 felony, and 3 counts of forgery, all Class 4 felonies. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing on the 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $10,000 secured appearance bond. If you post that bond and you are released from custody, you cannot have contact with any alleged witnesses of the underlying allegations, and you cannot possess any drugs without a valid prescription. Do you understand those conditions?
I do. I do have a question here.
Okay.
So given the circumstances of the facts of the findings of the case and the bond that I have to post, right, I don't have any access to my contacts or any way to, who would I speak to, or how soon could I speak to my attorney that you're appointing to me?
So in your release order, you will have the phone number to the public defender's office. So you can, as soon as you get access to a phone, you can use that phone number and start calling the public defender.
As soon as I walk out there, as soon as they let me walk outside?
Yeah.
Okay.
Unless they tell you, like, don't use the phone, go here. But as soon as you get access to a phone, you can use that phone number and start calling.
Okay, because, I want to go ahead and just see how soon I could start speaking with them so we can go ahead and get ahead of this matter and trying to
Yeah, you can give them a call as soon as you get access to a phone.
Okay, and then that's it. So just speak with them and then just go from there, right?
Sounds good.
Okay.
Yep, and go to court. If you post that bond and you're released, make sure you get back to court. All right, thanks, Ms. Pineda. Cruz Trejo to the podium in the courtroom, please. Cameron Gillings, if you'd please work your way to the second chair. If you would please work your way to the second chair. Can I have your name and date of birth, please?
Ramon Gomez, 4283.
Thank you, Mr. Gomez. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $5,000 secured appearance bond. If you post that bond and you're released from custody, you cannot have contact with any alleged co-defendants, and you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Gomez. You can step back and get your paperwork. Cameron Gillings to the podium in the courtroom, please. Javier Almejo to the second chair. Good morning. Can I have your name and date of birth, please?
10/22/89.
And what's your name?
Cameron Gillings.
Okay, thank you. It's Gillings?
Gillings, yeah.
Okay, thank you, Mr. Gillings. You are here on allegations of new charges. The allegations against you are 1 count of drug paraphernalia possession, 1 count of narcotic drug possession. Those are both felony allegations, and 1 count of theft, a misdemeanor allegation. I have found probable cause to support those allegations and appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $1,500 secured appearance bond. If you post that and you are released from custody, you cannot return to the scene where the alleged theft allegation took place, and you cannot have contact with the alleged victim of that allegation. You are also prohibited from possessing any drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yeah, how much is it, how much would that be? 10% of what, of?
Well, so 10% of 1,500 is 150, but if you want to go that route and use a bonding company, I would say call some bonding companies when you get back into the facility and check their specific requirements with them. My general understanding is they require a minimum of 10% down. Sometimes it's up to 20%, and there's also requirements on the back end. So I don't want to tell you what their specific requirements would be and be wrong. So when you get back into the facility, find a list of bonding companies and their phone numbers, and you can start calling them as soon as you get back there to see what their requirements might be.
So the bond is 1,500, right?
It's 1,500, yes, but it is secured appearance, so you can use a bonding company to get it posted.
Okay.
All right.
Thanks.
Thank you.
That would be 150, right?
Well, 150 is 10% of 1,500, but I can't guarantee you that that's what a bonding company would require in this case. So that's what I'm saying. Call a bonding company and see what their requirements would be.
All right.
Okay, thanks, sir. Marcus Copeland to the podium in the courtroom, please. Denise Barella, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Marcus Copeland, May 23rd, 1980.
Thank you, Mr. Copeland. You are here on 2 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of criminal impersonation, that's also a Class 6 felony. I have found probable cause to support those new allegations, and I have appointed a lawyer to defend you. Your next court hearings on the new allegations will be a status conference March 12th and then a preliminary hearing March 14th. They'll both be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $500 secured appearance bond. The second matter that you're here on is an allegation that those new charges violated Term 1 of your probation. In the probation case, I've also appointed a lawyer to defend you. Your next court hearing in the probation matter will be a revocation arraignment March 13th at 8:30, that one in the probation court downtown. On the probation matter, you have a $1,000 secured appearance bond. So your total bond will be $1,500. It is all secured appearance. If you post that and you are released, you cannot possess any drugs without a valid prescription, and you cannot return to the scene where you were arrested on the new allegations. Do you understand those conditions?
Yes.
Okay, thank you very much, Mr. Copeland. You can sit back and get your paperwork. Javier Almejo to the podium in the courtroom, please. William Morgan, if you please work your way to the chair. Good morning. Can I have your name and date of birth, please?
Javier Almejo, 1993, October 2nd.
Thank you very much. You are here on a bench warrant issued by the Superior Court when you failed to appear at a sentencing hearing in an existing felony drug case. You have a lawyer already assigned to you in that case. That lawyer will continue to defend you. Your next court hearing will be a post-warrant status conference. It will be March 12th at 8:30 in the Superior Court downtown, and you have a $500 secured appearance bond on that warrant. If you post that bond and you are released from custody, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Almejo. You can step back and get your paperwork.
Thank you.
Denise Barella to the podium in the courtroom, please. Reese Hartman, if you would please work your way to the second chair. Good morning. Can I have your name and date of birth, please?
Denise Desiree Barella, 72486.
Thank you, Ms. Barella. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case.
A status conference?
Yep, you have a lawyer assigned to you in that case already. That lawyer will continue to defend you. Your next court hearing will be a new status conference March 12th at 8:30. It'll be in the Superior Court downtown, and you have a $350 secured appearance bond on that warrant. If you post that and you are released from custody, you cannot possess any drugs without a valid prescription once you're released. Do you understand those conditions?
Yeah. Isn't there any way I can get out? Like, now?
By posting that bond, yeah.
Why so high, though?
I'm not the one that set that. The trial court judge is the one that set that bond when you missed that status conference.
And I didn't have a status conference.
You did. In fact, you did, and you missed it. You were not present.
No, they didn't notify me of that at all.
Talk to your lawyer. Talk to your lawyer about how you would have known about that.
Because when I went to my last hearing, I had signed a paper to go into
prosecution.
No. To go into a rehab facility, or not, to go into testing. And that's what we agreed on. He didn't say nothing about going to any, that was it.
Talk to your lawyer. Talk to your lawyer about all that. Okay.
So how long do I have to be here?
Well, if you don't post that bond, you'll be in custody at least until your hearing on the 12th.
All right.
All right, thank you. William Morgan to the podium in the courtroom, please. Anthony Lara, if you please work your way to the second chair. Okay, can I have your name and date of birth, please? Will you pull your arms out just while you're standing at the podium?
Yeah, William Thomas Morgan, 42285.
Thank you, Mr. Morgan. You are here on allegations of new charges. The allegations against you are 2 counts of shoplifting. They are both Class 1 misdemeanors. Because they are misdemeanor allegations, the nature of those charges does not entitle you to a court-appointed lawyer. What that means is if you wish to be represented, you will have to hire a lawyer to represent you. Your next court hearing will be an arraignment hearing March 26th. It'll be at 1 o'clock in the afternoon in the Goodyear Municipal Court. I am releasing you on your own recognizance, so you will be released from custody. Once you are out of custody, you will be responsible for getting yourself to that hearing March 26th at 1 o'clock. Also, once you're out of custody, you cannot return to the scene where the alleged shoplifting took place, and you cannot possess any drugs without a valid prescription.
Yes, ma'am.
Do you understand those conditions?
I do.
Okay, thank you, Mr. Morgan. You can step back and get your paperwork. Reese Hartman to the podium in the courtroom, please. Rodney Bowers, if you would please work your way to the chair. Good morning. Can I have your name and date of birth?
Reese Hartman, June 8th, 2002.
Thank you very much, Mr. Hartman. You are here on a failure to appear warrant issued by the Santan Justice Court on a misdemeanor criminal damage case. Because the underlying allegation in that case is a misdemeanor, you are not entitled to a court-appointed lawyer on that matter. If you want to be represented, you do have the right to hire a lawyer to represent you. Your next court hearing in that misdemeanor matter will be an arraignment hearing March 25th at 9 o'clock in the morning in the Santan Justice Court, and I do intend to release you on your own recognizance on this warrant. Assuming that you tell me that you believe you will be able to get yourself to court on March 25th at 9 o'clock. Do you think you'll be able to do that?
Absolutely.
Okay. The only reason I asked that is because it looks like you were served with this warrant while you were in custody, so I just wanted to make sure that you didn't think you would still be in custody on whatever else you were in on March 25th. So if you think you're going to be out and you can get yourself to that court hearing, I'm going to give you the chance to do that and release you on your own recognizance.
Okay.
All right. Thank you, Mr. Hartman. Go ahead and step back and get your paperwork.
Your next case is going to be done. By that day, because we're not going to take it.
Oh, really? Shit.
That's what I'm saying. If you're in custody and I release you, you won't be transported. So if you are out of custody and you can get yourself to this hearing, I'll release you. If you think you're going to be in custody still on the 25th and I release you, MCSO is not going to transport you. So you're going to pick up a new warrant.
Oh, yeah.
You'll be out of custody by March 25th.
I think so. I don't know. I think my first court date is April 1st.
Okay, well, that's after March 25th.
Okay.
So that's not going to work out. Okay, so here's what I'll do. I will put a small bond on this case. So I will give you a $50 secured appearance bond. The purpose of that is to ensure that you're transported to that hearing. It's also going to bump up your court hearing date. So I'll put a $50 secured appearance bond on this warrant. That means that your court date is now going to be March 11th at 8:30. MCSO will transport you to that hearing as long as you don't post this bond. It's also going to mean that you're entitled to a court-appointed lawyer for purposes of release conditions. So I will appoint a lawyer for you on the bond issue. Everything else will remain the same. So you have a new court date, you get a lawyer, and you'll be transported if you're in custody. If you post this bond, MCSO will not transport you. So if you have bonds globally and you can post all of them, go ahead and then get yourself to court. But if you're not bond eligible or you can't post all of the bonds, then don't post this one, and MCSO will make sure you get to court. Okay, any questions?
No.
Do you understand why I did what I did?
Yes.
Okay, all right, let me get this corrected and we'll print it and bring it out to you if you'll step back to your left. Thanks, Mr. Hartman. Uh-oh. I think I just did it on the wrong one. I for sure did. Yeah. No, that's okay. I think I know what it was. Okay, Anthony Lara, if you would please work your way into the courtroom. Eva Garza, if you would work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Anthony Lara, 5/16/89.
Thank you very much, Mr. Lara.
Yes, ma'am.
Okay, I'm sorry. Give me one quick second. Okay. All right, Mr. Lara, you are here on a failure to comply with court terms warrant issued by the Agua Fria Justice Court. That underlying allegation in that is driving on a suspended license. It is a misdemeanor allegation. Because that is a misdemeanor allegation, the nature of that charge does not entitle you to a court-appointed lawyer. If you want a lawyer in that case, you have the right to hire one at your own expense to work with you going forward. Your next court hearing on this warrant will be an arraignment hearing March 26th. It'll be at 10:30 in the morning in the Agua Fria Justice Court, and I am releasing you on your own recognizance. So you will be released from custody, which means it will be your responsibility to get yourself to court March 26th at 10:30. Once you're out of custody, you are ordered not to possess any drugs without a valid prescription, and you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, but one question.
Sure.
I know I forgot all about the charges. I know I need to pay them. The arresting officer told me I can pay those bonds and get out of it completely. So am I still able to do that? If I go to Agua Fria and pay it?
Possibly, yeah. I don't know. All I know is that the warrant was issued when you failed to comply with some court term. If it is the payment of a fine, it is possible that you can just pay that and not have to go to that court date. In your release order, you'll have the phone number to the Agua Fria Justice Court. Feel free to give them a call, or you can head down there and meet with them and see if you can get this resolved. If you can, great. But the only caution I would give you is, if you don't receive something from the court that court date on March 26th is canceled, still go, even if you think you've resolved the underlying issue, because I don't want to see you think that this is resolved, but the court still expects your appearance. And so here you are living your life thinking you've taken care of this, and then the court issues a warrant for your arrest when you don't go to that hearing.
Hey, it's how I got here to start with.
So yeah, yeah, exactly. So I would say give them a call, try and get this worked out. If you can, great. But if you don't get something in writing from them that this hearing is canceled, still go, even if you think you've resolved it.
Okay.
I'd rather you go to court and waste a little bit of time than end up back here and waste a whole lot of time.
Again.
Thank you, Your Honor. All right, thanks, Mr. Lara. Oh wait, I think, can we reprint that one since I messed the whole thing up? I just want to make sure he gets the right information. What I told you is correct. I just want to make sure your paperwork matches that. So we'll get it reprinted. We'll bring it out to you. It might have been.
You resent it right before, right?
Okay. All right. Rodney Bowers to the podium in the courtroom, please. Erica Arvisu, if you would please work your way to the chair. Good morning, sir. Can I please have your name and date of birth?
Rodney Bowers, 12265.
Thank you very much, Mr. Bowers. You are here on two different matters. The first matter that you're here on is allegations of new misdemeanor offenses. Those allegations are 2 counts of threatening and intimidating and 1 count of disorderly conduct. Again, they are all misdemeanor allegations. Because they are misdemeanors, the nature of those charges does not entitle you to a court-appointed lawyer. So I cannot appoint a lawyer to defend you, but you have the right to hire a lawyer if you wish to be represented. Your next court hearing on those new allegations will be an arraignment hearing March 26th. It'll be at 9 o'clock in the morning in the Wickenburg Municipal Court. The second matter that you're here on is a failure to comply with court terms warrant issued by the Hacienda Justice Court. That one is on a misdemeanor interference with judicial proceedings matter. Same situation in that interference allegation is a misdemeanor, so you are not entitled to a court-appointed lawyer on that second warrant either. Again, you still have the right to hire a lawyer if you wish to be represented. Your next court hearing on the Hacienda warrant will be an arraignment hearing at 9 a.m. on March 26th. That one's going to be in the Hacienda Justice Court. Mr. Bowers, your 2 court hearing dates are set for the same date and time, but they're in 2 different courts. I don't have control over those court hearings. So here's what I'll tell you. I am going to release you from custody, so you will be released on both of these matters, but I understand that you cannot be in 2 places at once. So what I encourage you to do is use the phone numbers to the courts and your release orders and see if you can get one of the courts to move your hearing, understanding that you have a hearing in a different court at the same time. Do you understand that information?
Yes, ma'am.
Okay, thank you, Mr. Bowers. You can step back and get your paperwork. Eva Garza to the podium in the courtroom, please. Carrie Durham, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Eva Garza, July 1972.
July what day?
July 7th, 1972.
Thank you, Ms. Garza. You are here on allegations of new charges. The allegations against you are 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 12th and then a preliminary hearing March 14th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I am releasing you on your own recognizance, so you will be released from custody. That means it will be your responsibility to get to those court hearings.
Yes,
and actually, I misspoke to you. I gave you the wrong date. Your court hearings will be March 20th and March 24th.
Okay.
So not the 12th and 14th, the 20th and the 24th. They'll still be at 8:30. They'll still be in the Superior Court downtown. You're still getting released, so you have to get yourself to court on the 20th and the 24th.
Yes, I will.
Once you're out of custody, you cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am, I do.
Okay, thank you, Ms. Garza. You can step back and get your paperwork. Erica Arvizu to the podium in the courtroom, please. Justin Holland, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Erica Arvizu, 9/8/1985.
Thank you very much, Ms. Arvizu. You are here on an allegation of a new charge. The allegation against you is 1 count of drug paraphernalia possession. It is a Class 6 felony, but I have not found probable cause to support that allegation. My finding of no probable cause does not mean that allegation is legally dismissed. It is possible that the county attorney's office will file charges on that allegation, but what my finding of no probable cause does mean is that you will be released from custody with no additional restrictions or requirements except for one, and that one requirement is that you attend court hearings. So the court hearings that you're going to be required to attend will be a status conference on March 20th and then a preliminary hearing March 24th. I have appointed a lawyer to represent you. That lawyer will defend you in the event charges are filed in this case. If you go to court, well, when you go to court on the 20th, it is possible the court will tell you nothing has been filed and you're free to go. But if charges are filed and you do not appear in court, that court will issue a warrant for your arrest. So you're getting out of custody, no restrictions or requirements other than that you go to court on the 20th and the 24th at 8:30 downtown. Do you understand that information?
Yes, thanks, Your Honor.
Okay, thank you, Ms. Arby. So you can step back and get your paperwork. Carrie Durham to the podium in the courtroom, please. Good morning. Can I have your name and date of birth, please?
Yeah, it's Carrie Durham, 7/26/88.
Thank you very much, Mr. Durham. Okay, you are here on an arrest warrant issued by the state of Kentucky. Before you were put on a court docket here in Arizona, Arizona confirmed with Kentucky that is a valid warrant. Kentucky has indicated that they are willing to extradite you, which means they want to come to Arizona and take you back to Kentucky. Before you came into the courtroom, did you get a big laminated card to review?
Yeah.
Did you read through that?
Yeah.
Okay. Because you are here on an out-of-state warrant, your hearing is going to look a little bit different than everybody else's, and you're going to have a choice to make. So I will go through what your two different options are. Hopefully what I tell you will be the same as what was on that card. I'll then give you an opportunity to ask any questions, and the last thing I'm going to do is ask you which choice you make.
Okay.
Okay. So the first choice that you have here is to waive your right to an extradition hearing here in Arizona and agree to go back to Kentucky. If you pick that first option, you are not waiving any defenses or rights you have to the underlying case in Kentucky. You are only waiving your right to an extradition hearing here in Arizona and agreeing that Kentucky can come get you. If you pick that first option and you waive your right to an extradition hearing, you will be held in custody here in Maricopa County for up to 30 days without bond. That 30-day time period will start ticking tomorrow unless you have unresolved criminal charges pending anywhere in Arizona. If you do, that 30 days will not start ticking until your local charges are resolved. So option one is waive your right to an extradition hearing, agree Kentucky can come get you, stay in custody for up to 30 days, no bond. Option two, if you don't pick that first option, is to demand to have an extradition hearing held here in Arizona and require that the governors of both Arizona and Kentucky sign warrants before you are taken back to Kentucky. If you pick that second option, I will set an extradition hearing for March 17th at 1:30 in the afternoon. In Arizona, extradition proceedings are civil, not criminal. What that means is I could not appoint a lawyer to defend you in the extradition proceedings, but you, like everybody else, would have the right to hire a lawyer if you picked option two and you wanted to be represented in the extradition proceedings. If you pick that second option and I set that hearing, you are bond eligible on the Kentucky warrant. Your bond would be set at $10,000 cash. If you posted that, you would be eligible for release while the extradition proceedings are taking place, but you would be required to stay in Arizona. If you did not or could not post that bond, then you would then stay in custody while the extradition proceedings are taking place. If you pick that second option, the time period from that initial hearing to getting warrants signed by both governors could take up to 90 days, but again, you remain bond eligible that whole 90-day time period. Do you understand the two different options?
Yeah, I understand.
Do you have questions about either option?
Not about the option. I have a question. So I'm on a 60-day, so they gave me 60 days to reinstate to probation.
In Kentucky?
No, here.
On a different matter?
Yeah, on a different matter. I'm doing 60 days just to go back into probation.
How far into the 60 days are you?
I've been here about 3 weeks.
Okay. So is the question going to be how does that affect this matter?
Yeah, like how does it affect it if I'm on probation here? How will I be extradited? Will it just they'll do that in Kentucky?
Serving the term of probation is not going to stop you from being extradited. So your term of incarceration will. So if you pick option one, your 30-day time period will start ticking once your 60 days is up.
Yeah.
And then Kentucky would come get you, or then Kentucky would have 30 days to come get you after that 60 days is up. If you picked to have an extradition hearing, those hearings would take place while you're serving your 60 days. It is possible that Kentucky will come get you while you're still on probation here. If that happens, what you would want to do is be very diligent about contacting your Arizona probation officer and letting them know what's happening and where you are and why. And then depending on what happens in Kentucky, whether Kentucky lets you come back or you stay in Kentucky, you just want to stay in contact with your Arizona probation officer, and they can give you what you need to do to complete probation or get it supervised in Kentucky or however it plays out in your case.
Okay, I'll choose option one.
You want to waive your right and agree?
Yeah.
Okay.
Yeah.
Because you are waiving a legal right that you are entitled to, I need to ask you some questions just for purposes of the record. The only thing I ask is that you answer out loud as opposed to shaking or nodding your head.
Okay.
Okay, did you read the waiver of extradition paperwork on that big, beautiful card?
Yes, I did, Your Honor.
Okay. Do you understand you do not have to sign the waiver of extradition paperwork?
I understand that.
Do you understand you have the right to have an extradition hearing held here in Arizona?
Yeah.
Do you understand you would have the right to hire a lawyer if you elected to have an extradition hearing?
Yeah.
Do you understand you have the right to demand that warrants are signed by the governors of both Arizona and Kentucky if you elected to have an extradition hearing?
Yeah.
Do you understand you would have the right to bond if you elected to have an extradition hearing?
Yeah.
Do you wish to give up those rights and sign the waiver of extradition paperwork?
Yes.
Has anybody promised you anything or threatened you in exchange for your signature on the waiver?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours that you feel would inhibit or prohibit your ability to waive a legal right?
No.
Okay, then I will find that you are knowingly, intelligently, and voluntarily signing the waiver of extradition paperwork. I will also sign. Once we both sign, then I will notify MCSO to notify Kentucky that you're ready to return. They'll have 30 days after your 60 days is up to come get you.
Okay.
Any questions before I ask you to sign?
No.
Okay, then unlike everybody else, I'm going to ask you to step to your right. I do need you to actually sign that waiver.
Okay.
Okay, Justin Holland to the podium in the courtroom, please. Oh, I'm sorry. Yes, I can. Can I have your name and date of birth, please, sir?
Justin Holland, June 9th, 87.
Thank you very much, Mr. Holland. You are here on 3 different matters. The first 2 matters that you're here on are Maricopa County probation violation warrants. In both of those cases, petitions to revoke your probation have been filed. Both of those allege that you have violated terms 3 and 5 of your probation. In both of those cases, I have appointed a lawyer to defend you. Your next court hearing in the 2 Maricopa County probation cases will be a revocation arraignment March 13th at 8:30. On those 2 warrants, you have a total bond of $750. It's $500 on one of the warrants, $250 on the other. If you post those bonds, we still have to deal with the 3rd matter that you're here on, and that is a failure to appear warrant issued by the state of Ohio. Before you were put on a court docket, Arizona confirmed with Ohio that is a valid warrant, and Ohio is willing to extradite you. That means Ohio wants to come to Arizona and take you back to Ohio. Before you came into the courtroom, did you get that big card to review?
Yes, ma'am.
Did you read through that?
Yes, ma'am.
Okay. On the Ohio warrant, I am going to go through the different choices that you have for purposes of that warrant. Hopefully the information I give you matches what's on that card. In the event it doesn't, or you have other questions, I'll then give you an opportunity to ask any questions about the Ohio warrant before I ask you which choice you're going to make. All right, on the Ohio warrant, because Ohio wants to extradite you and take you back, you will have to make a choice. You can choose to waive your right to an extradition hearing here in Arizona and agree to go back to Ohio, or you can demand to have an extradition hearing held and require that the governors of both Arizona and Ohio sign warrants before you're returned. Okay, if you pick option 1 and you waive your right to an extradition hearing here in Arizona, you are agreeing that Ohio can come to Arizona and take you back to Ohio. If you pick that option, you are not waiving any rights or defenses you have to the underlying proceedings in Ohio. You are only waiving your right to an extradition hearing here in Arizona. If you pick that option and you waive your right to an extradition hearing, you will be held in custody here in Maricopa County for up to 30 days to allow Ohio an opportunity to come get you. That 30-day time period will not start ticking until your Maricopa County probation cases are resolved. So if you pick option 1, you will remain in custody without bond on the Ohio warrant until your Maricopa County probation cases are resolved, plus 30 days to allow Ohio to come get you. If you don't pick that option and you pick option 2, then I will set an extradition hearing for March 17th at 1:30 in the afternoon. In Arizona, extradition proceedings are civil, not criminal. That means that if you pick option 2 and I set that hearing, I cannot appoint a lawyer to represent you. You would have the right to hire a lawyer to be present at the extradition proceedings, though, if you did pick option 2. If you pick option 2 and I set that hearing, you are bond eligible on the Ohio warrant. Your bond on the Ohio warrant would be $25,000 secured appearance. That means your total bond for all 3 matters would be $25,750. It would all be secured appearance. If you posted that bond, you would be released from custody. You would be required to stay in Arizona, but you could be out of custody while your probation matters are getting resolved and while the extradition proceedings are taking place. If you pick option 2 and I set that hearing, you then have to wait for governor's warrants to be signed by both states before your return to Ohio. Governor's warrants could take up to 90 days to be signed. However, that 90-day time period will run concurrent with the proceedings in your probation case. So option 1 is you have to wait for your probation case to get resolved, then wait 30 days. Option 2, the 90-day time period to get a governor's warrant runs at the same time as your probation case is going through those proceedings as well. Okay, any questions about the 2 different options?
No.
Do you know which one you'd like to pick?
Yes.
Which one?
I'll waive the right.
You want to waive your right and agree to that Ohio can come get you?
Yes.
Okay. Because you're electing to waive a right that you are entitled to, I do need to ask you some questions. I only ask that you answer them out loud as opposed to shaking or nodding your head. Okay, did you read the waiver of extradition paperwork on that big laminated card?
Yes, ma'am.
Do you understand you do not have to sign the waiver of extradition paperwork?
Yes.
Do you understand you have the right to demand an extradition hearing here in Arizona?
Yes.
Do you understand that if you elected to have an extradition hearing, you would have the right to hire a lawyer to represent you?
Yes.
Do you understand you have the right to demand that governor's warrants are signed by both Arizona and Ohio before you would be returned to Ohio? For assistance with, one's coming in now, so we'll just jump in if you're ready. Okay, good morning, sir. I'm going to ask for your name and date of birth here in just a minute, but before I do that, I want to let you know we are using a Spanish interpreter for your hearing. You will hear him, but you won't see him. I just ask that you allow the interpreter an opportunity to translate from English to Spanish. If you intend to communicate, please do so in Spanish, allowing the interpreter to translate that to English, even if you understand some or all of what I'm saying in English.
Buenos días, señor. En un momento voy a pedir su nombre y su fecha de nacimiento, pero se le deja saber que se está utilizando los servicios de una interpretación judicial. Eso significa que, aunque usted entienda lo que se ha dicho en inglés, por favor, espere a responder hasta que se haya terminado la interpretación al español y responda nada más en español, aunque usted entienda el inglés.
Okay, perfecto.
Okay, perfect.
All right. Can I please have your full name and date of birth?
¿Me da su nombre completo y su fecha de nacimiento, por favor?
Gustavo Christopher Fuentes Moreno,
Y nací el 30 de octubre de 1994.
My name is Gustavo Christopher Fuentes Moreno. Date of birth is 10/30 of 94.
Thank you very much, Mr. Moreno. You are here on allegations of new misdemeanor offenses.
Muchas gracias, señor Moreno. Está usted aquí por contención de nuevos ilícitos que son faltas.
Those allegations are one count of false reporting to law enforcement and one count of driving on a suspended license.
Las acusaciones son un informe falso a la policía, un punto acusatorio de conducir sin licencia de conducir válida.
I have found probable cause to support those allegations.
He determinado que hay motivo fundado para aceptar esas contenciones.
Because they are misdemeanor offenses, the nature of those charges does not entitle you to a court-appointed lawyer, but you have the right to hire a lawyer to represent you if you wish to.
Siendo de que son faltas, no tiene el derecho de que se le nombre un abogado defensor de planta, pero sí tiene el derecho a contratar su propio abogado.
Your next court hearing will be an arraignment hearing March 20th. It'll be at 1:30 in the afternoon in the Encanto Justice Court.
La próxima audiencia será una vista incoatoria el 20 de marzo a la 1:30 en el Juzgado de Paz de Encanto.
I am releasing you on your own recognizance, so you will be released from custody, which means it will be your responsibility to get yourself to that court hearing March 20th at 1:30.
Le voy a dar libertad provisional bajo protesta o palabra de honor, pero va a ser responsabilidad suya entonces comparecer a esa audiencia el 20 de marzo a la 1:30 en Encanto.
Once you are released from custody, you are ordered not to operate a motor vehicle if you don't have a valid driver's license.
Una vez se le da la libertad provisional, se le pide que no opere un vehículo motorizado sin licencia de conducir válida.
Do you understand those conditions?
¿Entiende usted esa condición? Yes.
Gracias.
Thank you.
Okay. Thank you, sir. You can step back and get your paperwork.
Regresa a recibir su documentación. Gracias, señor.
Lee, will you take him all the way out, please? Just one moment, Mr. Interpreter, if you don't mind, while we shuffle some people, and then we'll do the second one.
Of course, Your Honor.
No, it's him. Yeah. Well, he can come in here. You don't just take the other guy all the way out, and he can come in. Oh, you have to be in here. I can't be in here by myself with him. Oh, okay.
No, I'll be right back.
Okay. Okay, thank you, Lee. Sorry about that.
Good morning, sir.
Okay, good morning. We are going to be using a Spanish interpreter for your hearing. It sounds like you might speak and understand a little bit of English, but I'm going to ask you to allow the interpreter to communicate with you in Spanish. Please communicate back in Spanish, allowing the interpreter to translate to English.
Buenos días, vamos a estar utilizando los servicios de un intérprete judicial. Parece que usted entiende algo de inglés, pero por favor espere que termine de interpretar el intérprete en español y responda usted en español, aunque usted entienda el inglés.
Okay, can I have your full name and date of birth, please?
Muy bien, me da su nombre completo y su fecha de nacimiento, por favor.
El 10 de noviembre del 11 de 1998, José Ramón Piña Rojas.
José Ramón Piña Rojas, November 10th of 11 of 1998.
I'm sorry, can you tell me your date of birth one more time?
Por favor, disculpe, ¿me da su fecha de nacimiento una vez más?
10 de noviembre de 1998.
November 10th of 1998.
Thank you very much, Mr. Pena. Okay, you are here on allegations of new charges.
Está aquí hoy por contenciones de nuevos cargos.
The allegations against you are one count of luring a minor for sexual exploitation, a Class 2 felony, and attempted sexual conduct with a minor, a Class 3 felony.
Las nuevas acusaciones a su contra son inducir a un menor para propósitos de explotación, un delito clase 2, y actos sexuales con un menor de edad, un delito clase 3.
I have found probable cause to support those allegations, and I have determined that you are entitled to a court-appointed lawyer, so I've appointed one for you.
He determinado que hay motivo fundado para las acusaciones y que usted tiene el derecho a un abogado de oficio y le he nombrado un abogado defensor de planta.
Your next court hearings for these allegations will be a status conference March 12th and a preliminary hearing March 14th, both at 8:30 in the Superior Court downtown.
Muy bien, usted la próxima audiencia tendrá una una consulta de actualización el 12 de marzo y una audiencia preliminar el 14 de marzo, los dos aquí en el centro, el Tribunal del Centro.
On these allegations, I have imposed a secured appearance bond in the amount of $100,000. Secured appearance means you can use a bonding company to post that bond if you choose to.
Y en estas he dictado que exista una fianza de $100,000 para garantizar su presencia. Estos tipos de fianzas se pueden utilizar a un abonador para que deposite la cantidad de la fianza.
If you post that bond, Arizona law requires that you be affixed with an ankle monitor prior to your release from custody.
Si usted deposita esa fianza, la ley de Arizona requiere que se le ponga un monitor de griete para garantizar su presencia.
Sí, pero si yo lo deposito, o sea, si lo voy pagando cualquiera al mes o porque pues eso es lo que puedo hacer, pagarlo al mes, lento como mi trabajo.
Would I be able to make monthly payments on it? Because that's all I can do to pay it off.
Yo sí me comprometo.
But I do promise.
Yo sí me comprometo a pagarlo, me ponen, yo se lo pago, pero, o sea, yo trabajándolo, porque yo trabajo en construcción, quiero pagarlo porque yo sé lo que hice, pues, y yo quiero pagarlo lo que me ponga.
I commit to paying it, because I can pay this slowly because I work in construction. I commit to it because I know what I did, and so I promise to pay it.
Yo lo pago aquí.
Bond, here's the deal. You cannot be released from custody unless that bond is posted. It is not a fine or a penalty.
Entonces, la manera que funciona es que no se le puede dar libertad provisional a menos que se deposite la fianza. No es una multa, no es una sanción.
The bond is a requirement to secure your compliance with court proceedings and to ensure the safety of the public.
La fianza es un requisito para que usted esté en cumplimiento con protección del público y con los reglamentos del tribunal.
So that bond has to be posted to the court in order for you to be eligible for release from custody, but you can use a bonding company.
Ahora la fianza debe depositarse para poder tener la libertad provisional, pero puede usar una compañía de abonadora.
Once you get back into the jail facility, you can find a list of bonding companies and their phone numbers. They can give you further instructions on what their requirements might be, and they can answer the question as to whether or not they have options of monthly payments.
Entonces, cuando regrese a la cárcel, van a darle una lista de números de teléfono donde usted puede llamar para que le den más información de qué requisitos tienen ellos para usted poder pagar mensualmente.
Y el familiar no podría llamarlo en caso tal para hablar con ellos porque no tengo el número, no me lo sé, la verdad no me lo sé y quiero llamar a mi hermano.
Can a family member be able to call this and make this for me? Because I don't know the number really, and I want to consult. I want to.
Que no lo tengo, no me lo sé y ellos no saben y yo quiero llamarlo.
But I don't know that it's his number. I don't know his number. They don't know, and I want to call him.
Anybody can contact a bonding company to have that bond posted on your behalf.
Cualquier persona puede llamar a esta compañía de fianza abonadora a su favor, sí.
If you do post that bond and you comply with all requirements and attend all court proceedings, that bond is then released back to you.
Si usted deposita la fianza y cumple con todos los requisitos relacionados a esta, entonces ese dinero de la fianza se le regresaría a usted.
Okay, last couple things we need to talk about, Mr. Pena, is if you do post that bond and you're released from custody, you cannot have contact with any minors and you cannot access the internet through any electronic means.
Una cosa más, señor, si usted deposita la fianza y sale bajo libertad provisional, usted no puede comunicarse con ningún menor de edad ni tener acceso a internet a través de un medio electrónico.
Okay, thank you very much. You can step back and get your paperwork.
Muchas gracias por regresar a recibir su documentación. Thank you. And,
thank you very much, Mr. Mancia.
Of course, Your Honor. Thank you, Your Honor.
You are free to disconnect. Thanks. You take care, too. Do we have LBJ guys? Oh, we're doing it like later? Okay. And that's 17, right?
Correct, yes.
Okay, number 17 on the calendar, Juan Lopez, date of birth 9/26/72, is not in the courtroom because he is being housed at the Lower Buckeye Jail and is unavailable for transport. He is here on 3 probation violation cases. In all 3 cases, warrantless petitions to revoke allege violations of terms 1, 3, 5, and 15. I have appointed a lawyer for him in all 3 cases. His next court hearing will be a revocation arraignment March 13th at 8:30 in the probation court downtown. On these 3 matters, he has a total secured appearance bond of $1,250. Number 22 on the calendar, Andre White, date of birth 11/13/94, is not in the courtroom because he was unable to function in general population due to bizarre behavior. He is here on allegations of new charges. Those allegations are 1 count of criminal trespassing, a Class 6 felony, and 1 count of resisting arrest, a Class 1 misdemeanor. I have found probable cause to support those allegations and appointed a lawyer to defend him. His next court hearings will be a status conference March 12th and a preliminary hearing March 14th. They'll both be at 8:30 in Superior Court downtown, and he has a $500 secured appearance bond on those allegations. Number 24 on the calendar, Glenn Wingfield, date of birth 1/28/93, is not in the courtroom because he was unable to function in general population due to combative behavior. He is here on a failure to appear warrant issued by the Peoria Municipal Court on a misdemeanor matter involving consuming liquor in public and criminal trespassing. Because this is a misdemeanor matter, he's not entitled to a court-appointed lawyer. His next court hearing will be an arraignment hearing March 25th at 9 o'clock in the morning, and I am releasing him on his own recognizance. Last on the calendar, number 30, Roberto Lopez, date of birth 2/18/98, is not in the courtroom because he was unable to function in general population due to combative behavior, as well as posing a danger to himself. He is here on allegations of new charges. Those allegations are 1 count of sexual assault, a Class 2 felony, and 1 count of aggravated assault with a dangerous instrument, a Class 3 felony. I have found probable cause to support those allegations and appointed a lawyer to defend him. His next court hearings will be a status conference March 12th and a preliminary hearing March 14th, both at 8:30 in the Superior Court downtown. On those allegations, I have imposed a $500,000 secured appearance bond. If that bond is posted, he will be affixed with an ankle monitor from pretrial services prior to release. If he is released on that ankle monitor, he will be prohibited from returning to the scene where the alleged offenses took place. He will be prohibited from having contact in any fashion with the alleged victim. If anything changes when I visit these individuals cell side, I will come back in and update this recording. Otherwise, this court will stand in recess until 11 a.m.